Can you press item 5?
Also, it is not time of only compliance report is to be filed.
Okay. We were working on hiba, oral hiba. Oral hiba undisputedly is applicable in Muslim law. There is no qualm about it, settled law. It need not, it requires no registration. But there is a rider to it which has been held by the all courts that as registration is not required, is not compulsory, then it becomes more, basically there has to be more cogent and clinching evidence for the oral gift, because if there is any conflict, any discrepancy, then the benefit needs to go to the parties who are being affected by the hiba. It's a clear law. And this is because there is no document, there is no registration. So in the absence of all, it has to be clinchingly proved. The three aspects of declaration, acceptance and physical possession is settled law. The only issue is, what is declaration? It is not by writing declaration is a declaration. What is the stand of the defendants and the appellants herein, the contesting defendant and the appellants herein, that declaration was done, acceptance was done, possession was given, therefore it is complete. But it is complete only on paper. The real meaning of declaration is the intention. The meaning of declaration is making this to the public at large. You are declaring you cannot do this within the confines of your home. Means the public must know, as in the Lordship may know, that for the will in India, at least 2 witnesses are required to sign. They may sign at different times, settled law. One of the witnesses can come to the court. In Mohammedan law, they don't say the requirement is of at least 2 witnesses. The requirement is declaration to the public at large, means the society, the neighborhood, your members, the other legal heirs, all must know that you are basically bequeathing this property in totality to a particular person to the exclusion of all other legal heirs. The repercussions is very harsh. In that context, if Lordship may have this compilation, and the last page of this compilation, which is also the extract of the mullah, I'll just read 2 paragraphs, page 237, the last page of this compilation. I have underlined, I'm sorry, but that is only for the convenience of the. If Lordship may have para 2 of that compilation, this mullah's extract, this is section, this out 147. In order that a declaration of gift is established, it must be shown that the donor, either in the presence of witnesses or otherwise, made a public statement that he gifted the property in favor of the donee and that he divested himself of the ownership of the property by delivering such possession as the property is capable of to the donee who accepted the gift. So there are 2 aspects to it, that there has to be a declaration that he is doing it to the public at large and that he is divesting himself of the ownership as well as possession. He could live by as a user, he could live as a permissive user. Nobody is denying that once you basically bequeath anything by oral hiba, you are barred from entering. That is not the law. Your son can allow you to stay there. But the fact that you are divesting yourself of the ownership as well as the possession. So why I am emphasizing on this, that if any dispute arises, any litigation is there, either for ownership or possession, then you will not contest as owner or in possession. That's why I show the CNT proceeding. In that aspect, it is important. I'll further read. It is inconceivable that a declaration of gift can be made unilaterally by a Mohammedan without making a public statement of the gift. Declaration of a gift for the purpose of law has a definite connotation in the sense that a person making a gift must declare by some means to give public notice that he gifted the property to the donee and divested himself of the ownership of the property. It is unknown to the law that a Mohammedan can make an oral gift within the confines of his house and without the presence of anybody else, and canvass the plea that making such a declaration allegedly by the gift, the valid requirements of a gift are satisfied. The last two lines are very important. If evidence is lacking on any of the requirements of a valid gift, the law cannot presume that a valid gift has been orally made by a Mohammedan in favor of the donee. So there has to be sufficient cogent evidence to that effect that this gift was done. If Lordship may further escape the paragraph in between and then read this from similarly the Andhra Pradesh. Similarly, the Andhra Pradesh High Court in the instant case has observed that oral gift is a typical facility which is available exclusively to Muslims. Lordship has that last one paragraph.
Yes.
In the ordinary course, a gift is required to be made through a registered document as provided for under section 123 of the Transfer of Property Act 1882. When such a vital requirement as to the registration is relaxed, Lordship may mark this line,
Yes.
the proof in the form of oral evidence must be unequivocal and clinching. The benefit of any doubt or contradiction has to be given in favor of the person who is adversely affected in the event of the plea of oral gift being accepted. Any relapse in this regard is likely to provide an individual to trample the rights of other person to succeed in accordance with law.
So there has to be a positive evidence
Positive evidence
of declaration.
which must inspire confidence of the court.
Declaration per se must have a positive evidence. There is no question of
Doubting the veracity.
derivative.
Yes.
That because the possession was there and therefore
So
there
it
was
cannot be in reverse. The possession was there, therefore it must have been accepted, therefore it must have been declared. It has to go from declaration to acceptance to possession. So the first hurdle is not being crossed, and my question, because acceptance, he will say that I have accepted it. I cannot basically contradict. I can only show that the very first element of declaration is conspicuous by its absence, that there is no declaration in a legal sense. It is not a valid gift if at all they are pleading so. If Lordship may, in this regard, may have the compilation, the same compilation and the judgments which I will
and
be.
declaration in case of any oral transaction has to be what, when, where.
What, when, where is one aspect, and declaration to the public at large means that persons to whom you say either could be your neighbors, either could be your relatives, either could be your friends, all these persons must basically confirm this. Either you write in your recital, what we do generally when somebody comes to us and say that maine hiba karna hai, so I say that you do the hiba, let him accept it, give the physical possession, and after some time we do the recital and we write that on this particular memorandum of recital, which is also not registrable. That only records that on particular day this person bequeathed his property by way of oral gift to this person in his presence to him, which he accepted. He had a valid ownership, he accepted, and physical possession either constructively or actual was handed over. And he signs that in order to, and with the witnesses, so that it must come as an evidence to this effect, because generally the dispute with respect to hiba comes like a will after the death of the person who has done it. If it is in his lifetime, he will come and say that I have not done the hiba. Then another aspect which I will be pointing out from the judgment, that it must come on record as to what is the compelling circumstance as to why a father is bequeathing the entire property to a particular son
That
only.
is not required to be proved for hiba.
It is, but that needs to be seen. That is also one of the circumstances which is there in the judgment, that what was the compelling reason? Had it been a case that he was at loggerheads with other sons, he had given other properties to the other
That's
son.
going too far.
Anyway, I won't.
That's going too
I won't
far.
bother. I
And
won't
then
bother.
during the cross-examination, one of the witnesses has said that the property was handed over for the purposes of business. That is also there in the cross-examination.
No.
And admittedly, the others were not residing over there.
No, sure. Lordship, during the argument, my learned senior had given two facts which I was trying to oppose that time, as I was stopped not to say anything and say in my turn. He made a categorical statement that father was living with D1. He made this statement. He said that at the time after the 1967, he still stayed, and while the survey was still being done in his lifetime, he did not oppose. That shows that was his case, though it is not borne out from the records. The second aspect, they say that they constructed Pakka house after the Hiba. The second point he was raising, the facts he was pointing out. And the third, which is borne out from the records of the written statement, that the physical possession was handed over. My submission is that they ought not have written this, they simply would have, had the case been the real one, that as I was already staying there, so it was the constructive possession to my exclusion was given to me. Just in order to fulfill the criteria as given in the books, you copy down and write that declaration done, acceptance done, physical possession given, Hiba complete, I am the owner. It cannot be. It cannot be in a mechanical manner. It has to be borne out from the real and actual facts, and you should not conceal the facts, that you basically cannot twist the fact saying that the father was living when the evidence is contrary. Now, Lordship, coming to the evidence of DW1, 2, 3 and 4 as to what is the evidence for. I will point out the paragraph also only so that Lordship may not, I don't basically bother this court by reading the entire cross-examination. The cross-examination of DW1, who is Sanaullah, he says in 2023 to be 63 years of age. That means in 1967, he must be around 23 and 37, around 7 years of age. Sanaullah, who has deposed as DW1. I am taking the age from his evidence only. He says 63 years in 2023, 23 plus 33, 56, he is 63, means 7-8 years of age. The important paragraph of his deposition is paragraph 34, 35, 36, 43, 44, 45 and 46. Now I'll read only this paragraph. 34. विवादित जमीन अब्दुल गनी ने मेरे पिताजी एवं मेरे परिवार को रहने हेतु दिया गया, मीन्स रहने के लिए दे दिया गया था. He is talking about prior to the हिबा. अब्दुल गनी मेरे दादा गांव में रहते थे एवं कभी कभी जमशेदपुर आते थे. This is contrary to the what submissions made, just in order to prove or establish that कि सर्वे वगैरह हो रहा था, दादा वहीं थे और कुछ नहीं अपोज करते थे, because it is their own case that the Abdul Ghani was residing in village. If Lordship may have the cross examination, paragraph 34 and 35. In fact, 34 is repeated twice. If Lordship has DW1. It is on the left side in handwritten. Then Lordship may have para 43. Says that अब्दुल गनी द्वारा 1967 में दान स्वरूप दिया गया था. उस समय मैं 7-8 साल का था एवं बच्चा था. दान मौखिक दिया गया. Lordship has 43.
Yes.
44 ऐसी बात नहीं है कि अब्दुल गनी ने 1967 में मौखिक दान नहीं दिया था. मेरे पिता 1950 में आए थे. So it is their case that Wali Alam came to Jamshedpur in 1950 and he was residing there. The father was in the dada was in the village and he used to come to, and how frequently it not known to him. Last when came, not known to him. If Lordship may see, and in his examination in chief, which is important, is paragraph number 13 is important, where he for the first time names the 3 witnesses. That is important. Para 13. My grandfather Sheikh Abdul Ghani, while he was in position so and so, in favor of my father, in presence of Abdul Mateen, Tahir Hussain, Gulzar Ali, and other respectable persons of the community. So neither these three persons nor any other respectable persons were brought in the witness box. If Lordship, I read further, I'll first
He has
finish
stated this in para number 13.
13 of his examination in chief affidavit,
DW1.
which is the typed one, DW1.
DW1.
Yes. Para 13 is in second page.
My grandfather Abdul Ghani, while in possession.
Was in possession of the aforesaid land recorded in so and so or basing so and so. He orally gifted the same in the year 1967
He gives the name of three.
in favor of the presence of Abdul Mateen, Tahir Hussain, Gulzar Ali and other respectable person of the community. For the first time it comes in the knowledge of the court and the parties in 2023. Lordship has that?
Yes.
And if Lordship could see para 16 and 17, they say that my father was in possession of the aforesaid land. The present survey settlement operation commenced in the year 72. This is self-contradictory. Once you say that it has been bequeathed by way of oral gift in 1967 and the father gets divested of his ownership and possession, how could you write that my father, when he was in possession, the survey started? What is this possession of father is all about? It cannot be. Just in order to show that this survey was done in the presence of the grandfather. What he says that my father, while in, sorry, he is saying about the father. I'm sorry. Father means Valiyal.
Yes.
Sorry, I'm sorry. I'll take back that. What trying to say in 1670, it is nobody's case that they did it survey, got it survey from 72, name published in 79. Admittedly, the mutation was done in 89. Lordship, I have shown the records. Is it their case to say that this survey name was basically entered of his father on the basis of Hiba? That is nobody's case. They don't say that on the basis of Hiba, they got the survey in their name. Just because the survey was done, mutation was done, you can't reverse the process. You can't say that there is a survey, there is a mutation, there is a notified area committee, my father's name is all over there, and therefore I am in possession, therefore I am owner, and therefore the Hiba is correct is incorrect. What ought to be have been said, because they have not brought on record the documents leading to the change of the name of the father in place of the grandfather in the survey between 72 to 79 as the basis. What is the basis of the change of name? Hadn't there been case that on the basis of the oral Hiba, when the survey was done in 1972, which completed in 1979, my father's name, Wali Alam's name was substituted in the name of my grandfather, I can understand. But that is not the case. If Lordship, I further read DW2.
It is not their case that as a sequel to the Hiba,
No.
he
Yes.
got possession, and as a sequel thereto, his name was
No.
entered in the
No.
record of rights.
These are different facts. Fact of they staying in the property even before Hiba is established. They say that after Hiba physical possession was given. Suppose we give benefit of doubt that they wanted to say constructive possession, they wanted to say exclusive possession, benefit of doubt. But the fact of the matter, they don't connect this Hiba with the survey.
You see, lot of emphasis has been given on both the sides with regard to the physical possession of the property.
But that is never can be.
The three elements are to be independently proved. Each one of the element is required to be proved. Merely because one of the element is proved, they do not get any advantage, nor there can be any
presumption.
This is what is going in my mind, subject
Yes.
to what they have to respond to your arguments. They need to respond to my query also. Each element has to be
duly
independently
pleaded, proved.
pleaded and proved, maybe at least proved.
Unless they plead, they can't prove.
So any oral transaction with basic contours is required to be pleaded also.
Yes. And you
Maybe-
cannot just copy from the book.
Like when we say that there was a previous partition, we always under Hindu law we say that on such and such
The
day
oral partition was
there
there.
was an oral
Family
partition.
settlement was there,
Subsequently,
oral
it
was
was.
done.
This
So
is
there has to be some persons before whom it was
maybe
done.
even if persons are not there, if the parties have actually signed,
Signed
so
something.
there has to be the incident of HIPAA has to be relatable to some point in time, point in space, and
First, the foundation has to be put.
yes, that is absolutely absent.
So therefore,
I
I'm
don't
saying
get
that the
this.
rest of the things I don't need to be argued.
Yes,
So the basic foundation goes.
Merely and entry in record of rights, they are evidence of possession. They are not evidence of title.
But why, Lordship, I had shown that paper of page 81, 83 and 84 that while mutation is dakhil kharij. Mutation is basically that if any name is changed, Khatyan never changes. The owners are there. Original owners will be there in the Khatyan. If any by inheritance, by sale, then in register 2 and by way of mutation, the name gets re-entered of the actual owner at that particular time. When you enter a name in mutation doesn't give you a title. Khatyan you can't say, Khatyan cannot be changed. So the document is mutation. Mutation you cannot say on the basis of Khatyan Parcha. What is Khatyan Parcha? There is no concept of Khatyan Parcha. They have to show, because the column is very specific, whether by way of gift, succession, inheritance, sale, you have to show that on the basis of the hiba, my father's name got substituted in survey. Therefore, on the basis of that hiba, I want to get my name mutated. Khatyan Parcha kya hota hai? I couldn't get that. Khatyan Parcha will always say, Khatyan is what? Shows the genesis of the ownership. When you have sale deed in favor of 4 person, दादा उसके 3 दोस्त के नाम पे सेल डीड था 6 बीघा के लिए, दादा और 3 दोस्त ने मिलके एक पार्टीशन डीड बनाया और 1.5 बीघा अपने नाम कर लिए. तो खतियान में नाम तो या तो उन चारों का होगा या उन चारों ने जिससे खरीदा उसका होगा. मोस्ट प्रोबेबली जो उन्होंने जिससे चारों से खरीदा था उसका होगा. हम देखते हैं बिहार झारखंड में अगर हमारे बाप दादा की जमीन है गांव में और उसमें 100 साल 150 साल से खतियान में नाम लिखा हुआ है क्योंकि सेल डीड नहीं होता था, उससे हम ओनरशिप निकालते थे. यू कैन नॉट ड्राइव योर ओनरशिप फ्रॉम खतियान, दैट विल बी अ डिफरेंट प्लीडिंग्स and it cannot be on the basis of khatiyan and mutation because you are driving your ownership from hiba, and it is hiba and mutation is not linked. My point is that I am not saying that just because in the mutation they don't mention the case goes, because the law is even if the property is not mutated, hiba will not be challenged. It can be without mutation. Mutation is just for the purpose of property tax you pay to the government, that you make your record straight. It doesn't give you title. There, Mulla mein hi maine, Lordship, I have read it, the chapter, that mutation is not compulsory for that. Hiba has to be proved like a hiba. Its 3 principle they have to stand on their own legs. They cannot say just because mutation was done, the hiba is correct. All the more when hiba and mutation is not correct. Just because you got it survey, you got name, you got it in mutation, your name is there, you got it in the notified area, your name is there, but in none of the 3 authorities, before any of the 3 authorities, it is not your case that you got your name mutated, entered on the basis of hiba. It is nobody's case. This is my point. I am not on that, only on the basis of mutation, they must go. If they have proved the hiba, this mutation, irrespective of the fact whether they right or not, will have no consequences to either of the party. But this is one of the more important circumstantial evidence to show that this hiba story is an afterthought. That is the point I am trying to say from all this. If Lordship may have DW2.
DW2 para number.
Lordship, DW2, the important paras are para 3, para 10, para 12 and para 19 are important, and in examination in chief I have said para 3 Lordship.
Yes.
Para 3
10, 12,
is examination in chief. This is very relevant. This witness came after DW1. What he says in this para 3 Lordship, may I have that?
Yes.
Sheikh Abdul Ghani during his lifetime in the year 1967 orally gifted the aforesaid land to Wali Alam in presence of the witnesses and delivered possession of the same to Wali Alam. He did not even come out with the 3 names, despite the fact that the D1 had come with the names. So it is convenience who takes the name, who doesn't take the name. If Lordship may turn to para 10, what he says, मैं धनबाद में 1958 से रह रहा हूं, जमशेदपुर आना जाना 1975 से हो रहा है. Although it is not clear or borne out from the records that कि हिबा कहां हुआ था. अगर ये प्रिज्यूम भी कर धनबाद में तो नहीं हुआ था, दैट इज सर्टेन, कहीं नहीं आया. या तो भोजपुर में हुआ होगा, अगर इनका एक कहानी सही है, या जमशेदपुर में हुआ होगा. तो इनका तो केस ही यही है कि ये 75 के बाद से आना शुरू किए. और ये इनकी उम्र क्या थी उस समय, he was 70 years, so his age will also be around 14-15 years. He has said also 14-15 साल का था. पैरा 19 में मौखिक दान 1968 में हुआ था, उस समय में 14-15 साल का. पैरा 12 will be important that प्रतिवादी वलीउल्लाह हमारे सौतेले ममेरे भाई है. हाल में ही मैं वलीउल्लाह का समधी बना. मेरी बेटी की शादी वलीउल्लाह के बेटे के साथ. सो इट इज आउट ऑफ ब्लू विटनेस बिकॉज ऑफ बीइंग समधी. बेटी की शादी हुई है तो अपना फर्ज निभा रहे. कोर्ट में आके बयान दे रहे हैं कि ये हुआ था. यू हैड नो कंसर्न और कनेक्शन. यू आर नॉट द विटनेस. यू आर नॉट द पर्सन एट द रेलेवेंट टाइम. It is your own case that since 1958 I am in Dhanbad and I came to Jamshedpur only after 1975. So you are not the person in 1967 in any way whatsoever, and you are a samdi. Lordship may have DW3. The relevant paras will be para 10. Again he takes the name of 3. Para 38. So these 2 paragraphs are important. Lordship may have para 38. That will be of relevance. अब्दुल गनी के विरुद्ध 1972-73 में सीएनटी एक्ट का मुकदमा चला था, जिसे उन्होंने कंटेस्ट किया था. उनके बाद मुकदमा नंबर सीएनटी का मुकदमा चला. So in 1972-73, the grandfather contested a CNT case much after the alleged hiba. मुल्ला में मैंने अभी पढ़ाया जनाब कि he will be divested of his ownership as well as possession. So when the grandfather doesn't either have possession or title legally speaking, then he had no business to fight the CNT Act case, Lordship, which is there as Annexure 4 and 5, Exhibit 4 and 5, page 120 and 122. It is admitted case of the defendant becomes an admitted case that the grandfather from 1972 to 75 for the original CNT case as well as the appellate case, which is Exhibit 4 and 5 at page 120 and 122 of the paper book of the trial court of the volume 3. Lordship has that? So it is an admission. If Lordship could have DW4. Naushad Ali, the relevant para is the very first heading without para, जो मेरा नाम ये है, मेरे पिता का नाम ये है. Then para 4, para 14, 16, 17, 24, 27, 28. These are the paragraphs. Now I'll read this. नौशाद अली उम्र 72 साल, मीन्स ये भी 16 साल के थे in 1967. पिता गुलजार अली, जाति मुसलमान, सो एंड सो. पैरा 4, जिस समय मौखिक दान अब्दुल गनी द्वारा दिया गया था, उस समय मेरे पिता गुलजार अली, अब्दुल मतीन, ताहिर हुसैन तथा हमारे समाज के गणमान्य व्यक्ति उपस्थित थे तथा मैं अपने पिता के समय उस समय उपस्थित था. The point is that the name of Naushad Ali was not taken either in the written statement of defendant number 1 or the legal heirs of defendant number 1 or in the deposition of DW1, DW2, DW3. That is the point. Further, Lordship, I will read para 14. This is very interesting. He says, वली आलम के कहने पर आज गवाही देने आए. तो वली आलम तो वो थे जिन्होंने रिटन स्टेटमेंट फाइल करके इनका डेथ हो गया. तो हैड इट बीन अ केस दैट वली आलम के कहने पर ये गवाही देने, तो वली आलम 2015 में इनको बोल के चले गए थे कि मैं रिटन स्टेटमेंट में तुम्हारा नाम नहीं दे रहा हूं, लेकिन जब मौका मिलेगा 10 साल बाद तुम गवाही दे देना और बोलना कि मेरे कहने पे गवाही देने हैं. Can this be a believable evidence on the part of DW4 to say that कि वली आलम के कहने पे मैं गवाही देने और उनका बेटा जो है वो इनका नाम नहीं लेता है either in the deposition anywhere. So just in order to somehow enter and put his leg कि कोई semblance मिल जाए, छोटा सा कोई हो जाए कि गवाह है इसका. I'll further read Lordship para 16. मेरा जन्म 1951 में हुआ, दिन महीना याद नहीं. 1967 में मैं 16 साल का था. मेरा पैतृक घर जबलपुर मध्य प्रदेश का रहने वाला हूं. Now I'll further read para 24. अब्दुल गनी को 1961 से जानते हैं, वो अभी जीवित नहीं है. अब्दुल गनी भोजपुर में रहते. So again it becomes an admitted fact that Abdul Ghani was not staying in Jamshedpur. So they have to take what the witness says. Para 27. ये बात सही है कि अब्दुल गनी ने अपने पुत्र वली आलम को रहने एवं व्यवसाय करने हेतु दिए थे. मुझे याद नहीं है कि अब्दुल गनी भोजपुर से जमशेदपुर कब कब आए. जनाब एटलीस्ट वो तो बोलते कि 67 में आए थे या ये 67 में गए थे भोजपुर. फर्दर आई विल रीड लॉर्डशिप पैरा. I think these are the two only important paragraph. None. Now, on the basis of these evidences, which they had under 103 of the Evidence Act an obligation to prove the burden they have, whether they have been able to discharge the burden they had, I would say that they could not even start. What to say of proving it? If there will be a 1 to 10 points for proving a particular fact, it is not even they have crossed 1. If Lordship now may turn to the judgments which I will be relied on in the compilation.
The learned counsel for the respondents has submitted that the defendant number 1 and his legal heirs and successors who were claiming Hiba have miserably failed to prove the factum of Hiba. He has referred to the evidence of DW1 and in the year 1967, as per his deposition, he was 7 to 8 years of age. He has in particular referred to paragraph 34, 35, 36, 43, 44, 45 and 46 of his deposition. With respect to DW2, he has referred to his evidence in paragraph 3, 10, 12 and 19, and he has stated that in his evidence he has stated DW2 has stated that he was 14 to 15 years of age. With respect to DW3, the learned counsel has referred to paragraph 10 and 38 of his evidence, and with respect to DW4, he has referred to paragraph 4, 14, 16, 17, 24, 27, 28. He has submitted that DW4 was also 16 years of age in the year 1967. That should be sufficient.
And the name of DW4 was not stated.
He has further stated that DW4, the presence of DW4 was never disclosed at any point of time,
Either
And,
in the written statement.
either in the written statement or in the evidence of DW 1 to 8.
1 to 3. And when his positive evidence is that he is instructed to depose by Wali Alam.
And he has his positive evidence is that he had deposed at the instance of the defendant number 1, who
Regarding the
was-
factum of Hiba.
regarding the factum of.
Now let's come into the judgments. The compilation of judgments which will be relevant for Hiba, I will not bother much on that and just read. The judgments will be
Serial number.
I'll give the serial. Just give me a second. The first will be serial number 6,
6,
serial number 7,
7,
serial number 8,
8,
serial number 9, serial number 10. These are the 1, 2, 3, 4, 5 judgments on the factum of Hiba, which on various facts as to the date, time, place, discrepancies, and on that which I have read, I don't want to repeat that as there is no registration compulsory, therefore the court needs to see that there has to be clinching evidence. If I lordship just point out
and also Mullah, which you have already pointed out.
also
Apart from Hiba, these judgments and that extract from Mullah.
extract from Mullah on the last page, page
Last
237.
That's right.
Lordship, that may record
I
that.
will just record that. The Learned Council has referred to the extract from
Mullah.
Mullah's Principle of Mohammedan Law, 23rd edition, page number 184
180,
and 185.
185
185.
and the running page 237 of the
At running
compilation.
page 237 of the compilation to submit that the Hiba is required to be proved by unequivocal and clinching evidence. He submits that such such positive evidence in connection with Hiba is missing in the instance.
And all the more, Lordship, the declaration itself is not crossed. Out of the 3 limbs, the first limb is
The
declaration.
Learned Council has submitted that the 3 elements of Hiba, declaration, there are 3 elements of Hiba, declaration, acceptance and possession, and the first limb itself has not been proved. And each of the element is required to be proved independently.
Please, Lordship. I, Lordship, only to. I think I will be.
जजमेंट्स रेफर किए हैं सीरियल नंबर 6, 7, 8, 9 and 10 इसका डिटेल्स डाल देंगे पैराग्राफ नंबर इसमें लिखा हुआ
So I don't think I need to
No, we are
unnecessarily read all the paragraph.
not required. We have seen. I just one thing I want to know.
And Lordship, one more fact which I'm sorry, Lordship, may come on.
I just
Sorry.
wanted to know: is there any judgment indicating that time, place is absolutely required to be disclosed?
Lordship,
Is there any such law?
yes, the judgment in this, what I have referred this, is mentioned about the time, place and all that.
That is mandated.
No, it is basically, we won't say these things, time, place, date, the evidence of the witnesses, all this comes within that first element of declaration. So we will not say that each part is mandatory. These are the indications of the proper declaration. So on those points, the judgments are there where the dates were not mentioned. There are judgments where the witness had discrepancies. There is a judgment where the person did not name the person who was a witness. So that's why I am not
So
reading.
therefore, the evidence has to be taken as a whole to see whether there is a
The declaration is proper.
merely because one time is missing or
No,
maybe
need not,
date
need not,
is missing.
need not be. Suppose
That
nobody
may
say
not
that.
be
No,
by
it will
itself.
It will not. But when you don't have even the witnesses in the dock,
That's right.
there might be a situation that a witness says that it was somewhere in the month of October, November, I don't exactly remember, it will not go. As long as his stand is, he withstands the judicial scrutiny. That is the point. So therefore, mandatory part is the conglomeration of all these things.
That's
It is not a specific that date is mandatory, time is mandatory, place is mandatory. What is important is that declaration itself has to be by clinching evidence, by positive evidence, and needs to be pleaded and proved.
The learned counsel for the respondents has further submitted that, considering the totality of the evidences placed on record, the declaration has not been proved.
And one more important aspect, Lordship, this exhibit 4 and 5, which is the C&T case, read with that exhibit H.
The learned counsel has also referred to exhibit 4 and 5 to submit that even as late as in the year 1972,
72 to 75.
72 to 75, which is much after
The alleged Hiba.
alleged Hiba of 1967, it was Abdul
Ghani,
Ghani who was contesting the cases before the authority,
which has been admitted by DW3 also.
which has been admitted by DW3 also. Therefore, he was never divested, or he never divested himself from the ownership
Ownership as well as possession.
ownership and possession of it.
And one more argument which I had made, Lordship, is that the survey or mutation is not linked to the Hiba.
He has also submitted that the survey or mutation showing possession of defendant number 1 does not by themselves prove Hiba.
Hiba and does not link to the Hiba. It is
And-
not a consequence
and
of Hiba.
They are not linked to the Hiba in as much as there is no evidence to show that in the survey the name of defendant number 1 was entered pursuant to Hiba.
This is the.
That's it.
I think unless any other queries or
Query.
this is what I have tried.
Consistent.
Whatever little knowledge I had, I tried to assess this on good code.
Yes, please. You would need to respond.
Yes, sir. On few points only. Lordship, my first response would be to the point of Khatiyar, entry made into Khatiyar, which he's saying is not linked to Hiba or anything.
Entry in Khatiyan, is it your case that pursuant to Hiba, any
Indeed.
application was made for change in Khatiyan, or you were simply found in possession?
Lordship,
There
there was
two
a survey.
different things already.
There was a survey, Lordship.
There was a survey.
Under law, there is a presumption, Your Lordship, that the process of survey has been done as per law.
Certainly.
In survey, my name has come. That
Survey
Khatiyar
you-
has not been challenged till date.
Survey, maybe it has not been challenged.
So, and it was not even challenged in the suit, Your Ladyship, to the extent that how it has come or entered.
That's-
So, to that effect, I could have
No, therefore-
used evidence
so
and
therefore,
shown that he,
you see,
under what
Hiba was
circumstances.
not prepared in presence of the persons who were conducting the survey. Correct?
Indeed, Your Lordship.
So once the Hiba is done, then the person, is it your evidence that pursuant to Hiba, there was a change in the record of rights and therefore your name was exclusively entered? That is not your case.
Indeed, that is my case. Your Ladyship.
Where you are pleaded.
Show us.
Your Ladyship, that was my submission. That
Submissions and issues.
subsequent to Hiba, I got my name entered in the Khatiyar as in the process of service settlement. Now that Khatiyar was never challenged. Why I am submitting this, Your Ladyship, is that the action. Now, if they are saying there was no declaration which is essential to be proved, this declaration was alleged to be done in 1967, Your Ladyship. So, after the lapse of 60 years, there are
It's not
certain
it's not a
circumstances.
matter of lapse of 60 years because defendant number 1, the donee was alive.
At the time of the institution of the suit.
Yes, certainly he filed a
Yes,
written
sir.
statement.
So, Your Ladyship,
And what statement has he made, and how do you explain as to how another person is coming and filing the affidavit, verification, everything?
Your Lordship, on that aspect also I'll address Your Ladyship.
Yes, please address. Let us understand.
First on Hiba, Your Ladyship, if you will be permitted to finish. Your Lordship, now Hiba was done in 1967. After lapse of 50, more than 50 years, Your Ladyship, there are circumstances which cannot be ignored, which has to be
What is
ascertained.
that circumstance which
No.
cannot be ignored?
Your Lordship, in 1967 Hiba was done. Subsequent to that, Your Lordship, there are certain acts of commission done on my part, and there are certain acts
What
of
is that
commission.
acts of commission?
Your
on
Lordship,
your part?
mutation is one of the acts.
Mutation is much later, which was done on the basis of entry in record of rights.
The record of rights is prior to mutation, Your Ladyship, it was done. And Your Ladyship, there is one CNT Act which has been referred. The matter was under CNT Act in which the original father, S.K. Abdul Ghani was contesting. in that perspective, Your Ladyship, there is another proceeding which is Exhibit P, which order was passed in 9/5/1985. In this proceeding, Your Ladyship, the Dhoni was contesting the case.
The father was right.
Dhoni was contesting this
Father
case.
had died by that
Father
time.
died.
81 he has died. Yes, Your Ladyship.
So
In capacity
father
of owner, he was contesting, Your Ladyship.
No, in capacity of successor, he was contesting.
Then, Your Lordship, if that would have been the case, then every legal heir of the father should have been involved,
You
made
see,
a party in that case.
entry in record of rights by itself does not confer any time.
Indeed, Your Lordship, what acts of, when I'm speaking of circumstances, the acts of commission which I'm saying,
Just you tell us one thing. Whether the declaration has been proved by positive evidence or you are deriving it through possession.
no, Your Lordship, at this stage I will be relying on circumstances because no
Only
actual
circumstances.
the actual witnesses were not examined. That
So-
is the case. I cannot modify the case as
So
this.
therefore, the declaration by itself in isolation. Let us see the declaration in isolation. Declaration by itself has not been proved by cogent positive evidence.
But my
And your case is that because of these circumstances,
these circumstances cannot be ignored, Your Lordship.
yes,
That is-
certainly it cannot.
be ignored.
So therefore, there are three compartments,
Yes, Your Lordship.
right? One is declaration, then acceptance, and possession.
Yes,
There are three distinct compartments,
Lordship.
and each one is required to be proved.
Yes, Your Lordship.
Right?
So far as
Possession is proved.
Yes,
Let's take it. Possession is
acceptance
proved.
cannot be disputed, Your Lordship.
How?
Your Lordship,
Merely because possession is proved, therefore acceptance cannot be disputed.
Worship, he
And-
has not
and
even
because
he is not even a word that I was there to accept that. He has not
And-
even a word.
and so therefore we should all go backward and then say that merely because there was acceptance, there was a declaration.
But you are not saying backwards. At this stage, Your Lordship, my circumstances, which I say, and my circumstances not only include my act of commission,
In
their
response-
act of omission is also required to be
Just-
considered.
In response, the learned counsel for the appellant has submitted that the facts and circumstances of the case clearly proves Hiba.
Yes, Your Lordship.
Although the witnesses to Hiba, as disclosed by the evidence of the defendants for the first time during their deposition, were not examined for the reasons not
Known to anybody.
not available in the records. That's it.
Second, Your Lordship, when I am talking about speaking about circumstances, which I am saying there were certain acts of commission pursuant to EBA, which whatever the result may be, there
Where
was.
they have
I'm sorry.
they have not a word first that pursuant to this.
Just,
I'm sorry.
just
So, Your Lordship, my acts, what effect it will have, that is not what I am insisting about at this stage. What I am saying, Your Ladyship, there were certain acts which was done pursuant to HIBA to show my position and my title. But there were certain omissions on the part of the plaintiffs as well, Your Ladyship. The father died in the year 1981. Subsequent to that, in 1979, entry was made in Khatian, not objected, not challenged till date. Mutation was done in 88, 89, not objected, not challenged till date. Worship, there's a in correction slip, there is a Uttaradhikari Dakil Kharij also which is required to be filed. They have till date not filed that. So there was complete omission on the part of the plaintiffs as well, and that in relation to my acts of commission and their acts of omission, Your Lordship, shows that there was a declaration. There was a valid declaration, and Your Lordship, the date, so far as the date of HIBA is concerned, Your Lordship, that is 1967. This year is consistent. There is no date, no time that I admit, Your Ladyship, but the year is consistent with all the witnesses and all the everywhere, Your Ladyship. There is no inconsistency with regard to the date, the year of the HIBA. Second, Your Ladyship, the question regarding under what capacity the WS was verified by one of the sons, Your Ladyship, that issue was never raised before.
we are raising it first.
Yes. Your Ladyship, but
Affirmative.
at this stage, how I will satisfy under what circumstances it was done? At this stage, Your Ladyship.
The circumstances of filing written statement by somebody else,
What?
it has to be reflected from the written statement itself.
It is not, Your Ladyship. Instructions which I have taken because it has been raised first time over here, Your Ladyship.
I don't
And
have
which
to
he has,
show from the records and it don't have to show.
he
This
admitted,
is your document.
he admitted in the submissions before Your Ladyship that he raised this issue but did not assailed before the trial court.
No, it's not assured. I'm saying that I'm taking benefit out of it.
So, ladyship, what instruction I had, he was ailing, he was not keeping well, so it was verified by one of his sons.
That you have to plead that.
If it would have been raised, your ladyship, I would have pleaded. It was never raised. And it was admitted and accepted, your ladyship, by the plaintiffs as well. Second, your ladyship, so far as entry in correction slip, which has been argued that in correction slip it is not mentioned whether by which mode he has acquired the title is concerned. Correction slip was done in the year 88, ladyship, subsequent to entry made in Khatian. So once the entry made in Khatian is there, your ladyship, it was not required in the correction slip to show original how and under what circumstances have acquired that property. So that entry which stays on the basis of Khatian Paicha is not incorrect. And the last aspect, your ladyship, about the partial partition, which the judgments which he has relied upon, those judgments, your ladyships, are of the year 1960, 1915 and 1922. Those judgment which I have referred to is subsequent to these judgments, which is of 1971 of Honorable Supreme Court. These are of...
you have not been able to answer one query of this court, that when we talk about partial partition, partial has two elements. One is partial qua co-owner or co-partner or a brother,
Co-tenants.
co-tenant, and partial qua properties.
Yes,
Yes, we have seen that.
So the
We have
word
seen
which has
that.
been used is
You-
that is the entire, every part of the state. State includes every
Every
part
part of the state person will have equal share.
Yes.
So one
And
property can
it
be
has to be
divided
taken.
equally, the second property can also be divided equally. Correct?
Yes, that is it, but
This is
partial
what I am
partition is not
observing. Therefore, partial partition means that it is not possible that out of 5 brothers, one is not a party. Like in Hindu law, one person can come and say that you separate me, I am not bothered about others. Still the others will remain intact, their family will remain intact as joint family, but one will get separated. That kind of partial partition is not permissible under the Mohammedan law. This is what is not permissible. It does not say that qua a particular property partition
But
is
that
not.
distinguish
That
that
one,
has not been
I
distinguished.
can't
in
say
the
anything more than
1971.
Mullah says. Lordship, one clarification I'll just say. I'm sorry. I'm sorry.
So, Lordship, when I am relying on the judgment of 2024 and 1971, even that judgment does not bifurcate according to that it will be qua the tenant or qua
That
the
is why you are arguing
And
for 2
what-
days before the court, isn't
and
it?
what it is saying is
Anything which has not been clarified by Supreme Court, right,
But
can
you-
certainly be clarified by this court. This is what is going on in my mind, and therefore I am absolutely vocal about it.
But your Lordship, when it is specifically saying no
And-
partial partition,
And
so as a
and,
whole
and
no partial
in the
partition.
judgment of Honorable Supreme Court, I think in 2024 or maybe 1971, I don't remember exactly. The preceding paragraphs reveal under what circumstances the Supreme Court is talking about partial partition. The Supreme Court has said that if one of the person from Hindu co-partner goes to say that I want to be separated, that is permissible under law, and this is what is not permissible under Mohammedan law.
Yes.
That's it.
So that bifurcation is not there. So when I read this judgment, I will read partial partition as a whole, an entire state relation.
That's a part of your duty. You have to read it. There is no option.
Lordship, one clarification I just wanted to do.
Let him finish.
I'm sorry.
So Lordship, my
Okay, so
submission-
एक second. The learned counsel has further submitted that the entry in record of rights, which was finally published in the name of defendant number 1, attained finality, and therefore there cannot be any doubt that defendant number 1 was the exclusive owner of the property and was also in possession thereof.
the acts of omission.
The learned counsel has submitted that at any point of time, the plaintiffs did not raise any objection with regard to entry in record of rights or also at the stage of mutation. And there is serious omission on the part of the plaintiffs to claim the property. And such omission was essentially because of the reason that the property was subject matter of Hiba. That's all.
May I just in one line, may I clarify this? First thing, Lordship, the survey or the mutation does not confer title. First thing. Second thing, Lordship, he says that on the basis of Khatyan person, he got it mutated. So therefore, it is not stated that it is on the basis of Hiba. It is to be seen that Khatyan में कैसे मेरा नाम आया. Is it his case that his Khatyan नाम में जो change हुआ है, that is on the basis of Hiba? That is not his case. So this is what I am trying to say, that in survey you change the name, but you don't come out to the court saying that survey का नाम मेरा हिबा के बेसिस पे चेंज हुआ. It is not his case. खत्यान में corrections हिबा के बेसिस पे हुआ, not his case. Mutation हिबा के बेसिस पे हुआ, not his case. So this is what I am trying to say. And the subject matter of suit is hiba. Much okay.
Since the Khatyan was never challenged, these things were
I don't
not
have-
pressed, no evidence was led, under what circumstances the entry was made in Khatyan. So these
You have to prove your case. I don't have to.
Lordship,
103. Much obliged, Lordship, for the patient hearing.
As date क्या?
18.
Who's for judgment on 18th August?
As Lordship. And I must compliment my young friend. He has done his duty.
Certainly.
Despite having so
And
adverse.
don't, my observations, please don't take it for granted. I have still to write my judgment.
Yes, yes. Should. That is always open. Much okay.
Questions are required to be put so as to clear my mind.
Please. If Lordship has any query to me, then
That's all. I have put enough questions.
shall I submit a written
No.
submission?
No,
Much okay.
not required. Because every submission of yours I have recorded in open book. ये जो बैच है ना ये इसमें there is a batch of 3 cases. Yes, your matter is there. Just please hold on, just hold on. आपका वो पार्ट डिक्टेशन मैंने दिया था पिछली बार है ना? तो in one of the cases you have already submitted your written submissions. बाकी तो contours of the argument, contours of the case we have already recorded. The second and third are also similarly placed to some extent, right? So I will just reserve the judgment on this. Is that okay? Because it's only my dictation. I don't want to,
Yes, yes.
lot of time will be consumed. because
I
of that.
completely subject to the other side.
We don't. For reserving the judgment, I don't need because I was in the midst of the dictation.
Yes, we have
I
already
was-
given these.
Everything has
the
already
judgments,
been done.
There are two written notes.
We
are
have
also.
started the dictation
Yes,
of the judgment, so there is no question of any consent from any other side, right? So these 3 matters would remain same, right? There is one more matter. Second appeal.
Yes.
That was for further arguments. Or that was for further arguments. Okay, you just wait for a second. Just wait.
Item 3.
Item 3. You just convey.
Last date, yes, Prat.
You just
My
convey.
lord has observed, so that's why he was online. I'll just convey.
He is here only.
Yeah, I'll just convey.
Okay, he is here only. He is there online. Can you see him there?
No, not yet.
Oh, वहाँ पे screen नहीं रहता. Yes, Mr. Srivastava.
I'm listening. I'm also I'm listening.
It's quite a long judgment. So
Yes.
I just on that day we had recorded the case at least of the point for determination also we had recorded. So it will remain same.
We are here to assist your petition.
No, that's right, it's okay.
Other than assisting if required, otherwise.
No, not required, not required.
So,
इनका appearance online record.
I'll just give us.
हाँ, give us other side का हमको बुलाइए, बुला के उनको खबर करें. Yes, second आपका क्या है आज? First case.
आइटम 1 जो है
हाँ
सेकंड अपील 89 of 16 as it was filled.
हाँ है बुलाइए.
Yes.
Call करिए.
From daily list, item 1 second appeal 89 of 2016.
You are there in this case?
Yes, Your Lordship.
हाँ ऑर्डर रिजर्व कर. आपका भी रिटन सबमिशंस है, उनका भी है मेरे पास, और आप लोग का पॉइंट फॉर डिटर्मिनेशन तक तो हम डिटेशन दे ही दिए. इसका रिकॉर्ड्स
Lordship, we were supposed to file written synopsis in this matter, Your Lordship. We have received the written synopsis of the applicants yesterday and moved an adjournment slip, Your Lordship. Your Lordship.
your
My
adjournment
senior-
slip.
Yes, Your Lordship. Yesterday only by email, Your Lordship.
मेरा तो ऑलमोस्ट मतलब आर्गुमेंट हो ही गया था लीगल पॉइंट्स में.
There are
Lordship,
few more
also
arguments
we
that
have
has to be
recorded.
advanced, Your Lordship, by
But
proceeding.
थोड़ा
थोड़ा सा, there are other sections also that they have to be looked into, Your Lordship.
ये मतलब रिफ्रेश लॉर्डशिप.
Where is your written submission? आपने दिया है, फाइल किया है, फाइल कर दिया है.
Yes.
हाँ, ये this one.
ये पासवर्ड अंदर को.
No, it's okay, it's here. They are seeking time. What should I do?
आइए इसमें क्या बोले, कभी कभी हमारे तरफ से भी टाइम लगता है. बट मतलब मेरा आर्गुमेंट हो गया था. एक लीगल क्वेश्चन है जो ऑलरेडी आप रिकॉर्ड कर चुके हैं. वो यही था माइनर कि 87 हुआ ये कि सेक्शन 89 CMT एक्ट में प्रोसीडिंग हुआ बिटवीन द पार्टी. There was an order passed in 86. Because thereafter a suit was in suit under section 87. I had objections that it is barred by limitation, and proviso to 87 bars such a suit when the issues have been settled between parties. The court decided against me. Both the questions remained undecided. उसके बाद ही लोग अपील किए. I preferred appeal. My appeal has been rejected without deciding those questions on the basis of an extraneous third suit, which has no concern and that will not be hit by proviso. इतना ही केस है.
I remember.
Your Lordship, the question was on limitation, Your Lordship, whether section 5 of Limitation Act would apply on a suit or application under section 87 of CMT Act, Your Lordship. This had to be decided if it is a suit or it is to be tried as a suit in a civil proceeding or an application, Your Lordship. There are few more submissions that the senior would like to make, Your Lordship. We are seeking an adjournment, Your Lordship. Conclusively, we have to decide.
Essay number 89 of 2016. Learned counsel for the parties at present. Learned counsel for the respondents. Seek adjournment to comply the order dated 7/5/2025. When do you want? When do you want?
If it could be on the first week of July, Your Lordship.
Post this case on 3rd of July. Written notes of argument in terms of the last order should be filed latest by 30th 26 June. Latest by 26 June, failing which the same will not be accepted. बाद में मत लेके आइएगा, हम accept नहीं करेंगे.
अगर एक चीज खाली वो लिखा देते
और कॉपी उनको दे देंगे.
एक लाइन अगर लिखा है कि आर्गुमेंट्स फ्रॉम आवर साइड इज ऑलरेडी ओवर.
ऐसा नहीं लिखा सकते. इतना दिन बाद केस टेकअप होता है ना, तो थोड़ा रिफ्रेश करना
तब
जरूरी है.
होता है क्या कि जब फिर हम लोग का बड़ा एक्सरसाइज कभी कभी अन्य कारणों से बढ़ जाता है. वो हम नहीं चाहते कि अन्य कारण दोबारा फिर री एक्सप्लेन करो सब चीज.
करना ही पड़ेगा उसके लिए, तो आप ही लोग जिम्मेदार
नहीं
हैं.
नहीं, आप क्या तो नहीं करना पड़ेगा. आप बोल क्या रहे हैं.
हम जान रहे हैं, लेकिन ऐसा नहीं कर सकते.
From the supplementary list, reading for finals will item 2, essay 40 of 2020.
Seeking adjournment.
We were seeking adjournment because yesterday itself I received the NCR. It's from my
Last time कब हुआ था ये मैटर?
last time, last week ही हुआ.
11/6. 11/6 से 17/6 तक
कल ही हमको मिला. अगर
मिला है मतलब आपको इनविटेशन कार्ड भेजे हैं?
I don't.
Then?
I won't say that invitation.
आप जब आइएगा तभी ना
No,
मिलेगा.
no, I asked me, I tried to contact
आपने
him.
नहीं दिया.
And I
आपको
tried
मिला.
to, he gave me yesterday.
लेकिन ये हमसे कल
हाँ, कल हम मुझे 2 दिन से ट्रेस कर रहे थे. अगर वो है तो वैसा इशू नहीं है उसको कि हम उसको ये क्योंकि it's a 736 pages document comparison. So that's why we need to assess the book.
कोई बात नहीं. अब आप लोग की ये सब चीज़ के कारण तो हम लोग जिम्मेदार नहीं हो सकते ना.
जी भाई.
Essay number 40 of 2020. Learned counsel for the parties are present. Counsel for the appellant seeks adjournment for at least 4 weeks by submitting that the original file is not available.
No, I did not see.
It is mentioned over
No, it
10/6
was
को.
not
10/6 को.
It was not my mention.
अच्छा,
मेल में अलग था.
ठीक
2
है.
weeks के लिए.
2 weeks के लिए. Has prayed for 2 weeks time. And has submitted that. We shall also आपने अपना written submissions file कर दिया.
नहीं रिटर्न सबमिशन
के लिए अलग से ऑर्डर करना.
नहीं और उसमें कुछ सबमिशन करते हैं.
The learned counsel for the parties have also submitted that they will be submitting their written submissions
Yes, please.
with the consent of the learned counsel for the parties. Post this case on 28th of August under the heading for hearing. Final disposal से हटा दीजिए. अपने आएगा जब. चलिए. It will come for hearing. 28 अगस्त.
Item 3,
इसको
second.
फाइनल डिस्पोजल से हटाना है.
Yes, yes. Item 3, second appeal 190 of 2022.
Where is the respondent? Have you responded to this IA? Have you served him?
Yes, sure.
What additional where is the original substantiation of state? By which order?
Order dated 6/2/2025. On last occasion, respondents sought time on this issue.
Are you ready?
DT.18.06.2025.
He is absolutely clueless. इनको बिना सुने तो कोई additional substantial question of law भी नहीं बना पाएंगे. Who will argue your case? Where is he?
Council detained on
You see, such kind of reappreciation of evidence is not permissible under second appeal. Unless you have to show perversity, you can't just pick up one paragraph of the examination or cross-examination and then you say that this is the substantial question of law. That is not the manner in which a substantial question of law. Either you say that it is perverse.
Look, we are relying that it was admitted case of the defendant that, if your lordship may kindly come to paragraph 5(1). Our case was rejected on the ground that there were two prayers. Firstly, the cedit which was entered by the original lawyer in favor of this defendant, that should be declared null and void. And second was for declaration of my right title. As far as first is concerned, my case has been rejected. That is not the issue before this court now, because that is. As far as second point is concerned, declaration of my right title is concerned, what I am trying to show before your lordship, that he has admitted that my vendor had 19 decimals of land. His specific case was that he could not have transferred more than 6.5 decimals of land because he was not in possession of more than 6.5 decimals of land. But in WS as well as in evidence, he has admitted that he already had 19 decimals of land as well as possession over this. So there was no incumbent, there was nothing. Both the learned courts should have declared my right title and there the perversity lies. The second one, your lordship, maybe that is on the basis of admission in the evidence, but the first one is admitted in the WS as well as in the evidence. Despite that, the learned court below have not declared my right title.
The right claim was possessory right.
Possessory
Or it was
right.
title.
Both. Right title. Our case was that we have purchased 9 decimals of land from a Gunadhar Ghosh and we claimed right title interest on that basis. Defendant said that Gunadhar Ghosh did not have more than 6.5 decimals of land. My sale deed was not under challenge, nothing was challenged except the area. But in the WS he said that Gunadhar Ghosh was having possession of 19 decimals of land, out of which he purchased 6.5 decimals of land. Thereafter also 13 decimals of land was available. So he disproved his own case. So there was no impediment in declaration of my right title in interest. And that is the specific case in the WS also and in the evidence. If your lordship may.
5(1) को खाली frame कर.
No, 5(1) that would suffice.
क्या बोलना है आपको? Yes, counsel. What do you have to say? You are clueless. You have nothing to say. ये क्या forgery किए हैं क्या? कोई पासओवर का काम नहीं है. ऐसे नंबर 190 of 2022 with IA number 6915 of 2025. This interlocutory application has been filed for framing additional substantial question of law. The learned counsel for the appellant has submitted that additional substantial question of law number 5 within bracket 1 is proposed as the same is based on the admitted facts on record, upon which would be apparent from the perusal of the plaint and the witness statements. He submitted that it stood admitted by the defendants that Gunadhar Ghosh was left with 13 decimal of land out of his total land of 19.5 decimal after he had sold 6.5 decimal of land to the defendants. Learned counsel for the respondents, upon asking of this court, has not made any submissions with regard to the additional substantial question.
Perhaps it may reply on the additional question from the readings only.
Yes, Krishna.
Now so for the records are here. The basic case, the cause of action was there, that they said we have purchased 9 decimals of land from Gunadhar Ghosh, the plaintiff's mother's name. And their case was that they have left on the eastern side, they have not given boundary, it is open. And now they came out with a case that we are trying to overlap or grab that land, which is purchased by them. So, in nutshell, it was their case that this suit land, the suit land is a small portion of land. It is 165 into 17 square feet. They have said somewhere it is 15 feet wide. That this suit land, that is Schedule B land, this suit land is part and parcel of their purchased 9 decimal of land. We said, our written statement or our evidence, we said that there could not, 9 decimals of land could not have been sold to them because Gunadhar Ghosh was not having 9 decimals of land. That was our case. That is one part. And now their case, to substantiate that it was open and we are trying to overlap, they came out with a case that this plot number 259, which comprised of the suit land, this has total 64 decimals of land. Out of that, 62 decimals of land were already sold. Only 2 decimals of land were remaining. So they were saying that our sale
The
rate.
learned counsel for the respondents has opposed the prayer. However, after perusing the records of this case, this court finds that the aforesaid substantial question of law does arise for consideration. Accordingly, this appeal will also be heard on the aforesaid additional substantial question of law, para 5 within bracket 1. कब करना है खाली बताइए. आइए disposed of. Records आ गया. कब करना है? If there is an admission, we shall see इसके beyond.
Yes.
बात खत्म.
We have no objection to framing of substantial question. We have no such serious objection.
The council has no serious objection so far as framing of additional substantial question of law is concerned. Done? बताइए कब करना है?
Any date which is convenient to this honorable court, and otherwise I am ready on the facts of the case, whenever it is convenient to this court.
बताइए आपको कब करना है?
Any day.
नोट्स बनाए हैं आप लोग?
Written notes of argument थोड़ा सा उसमें change करना पड़ेगा.
आप बना लिए?
Yes, I was.
ये बात सकते हैं.
Yes.
Post on 25th August, counsel for the parties have undertaken to file short synopsis of arguments, latest by 13th of August. अभी इतना जल्दी नहीं हो पाएगा, कुछ मैटर्स फिक्स्ड है, कुछ जजमेंट्स है लंबे हुए हैं, तो थोड़ा सा
Okay.
चार बजे कौन सा केस रखा है?
Out of turn fixed case item 20. Second appeal, AP of 2011.
Respondent, where is the respondent?
उनको कह दिए
कह दिए से नहीं होगा ना, लेके आना था, ऐसे नहीं सुन सकते. Not possible. ऐसे तो कैसे सुन?
2-4 मिनट देख लेते हैं, 4 बज
ठीक
रहे हैं।
कोई बात नहीं। देखिए तो ऑर्डर्स वाले भी केसेस हैं। कोई और कोई पर्टिकुलर मैटर है आज? आप लोग इतना भीड़ है आज, इसीलिए पूछ रहे हैं। हाँ? Is there anything particular? ऑर्डर्स कॉल कर लेते हैं।
Under heading 4 orders, item 6 FA 23 of 2015.
In course of hearing, was intimated on 8th of April 2025 about death of one of the respondents. Therefore, after inquiry, we filed an IA number 7217 of 2025. Although they were not sure, they still not, after inquiry found that one respondent number 6 died. And we filed an IA mirror that is 7217 of 2025.
Notice has to be.
Yes.
IA number 7217 of 25. The council for the applicant has submitted that respondent number 6 has expired. During the pendency of this case?
Yes.
During the pendency of this case, the name of legal heirs and successors have been mentioned in paragraph 7 of the interlocutory application.
There are 7.
Issue notice to the proposed legal heirs and successors of respondent number 6, whose details have been mentioned in paragraph 7 of the interlocutory application, under ordinary process for which requisites be filed within a period of 1 week. Notice on interlocutory application.
Your Lordship, on the last date, however, I will inform the court respondent number 5 has done, Your Lordship.
In fact, we have made inquiry and we responded 6.
5 has not died.
5 has died. Actually, Your Lordship, we are querying for many respondents. We are not in contact with any of the respondents, Your Lordship. We've tried
That
to
is also
contact them.
recorded on
That has been recorded.
Do you
on
want
the
to
last
say
date.
that respondent number 5 is alive?
I
No
do not
idea.
know, we have made inquiry only responded 6 times.
The learned counsel for the Upari Vikita has submitted that although on the last occasion it was informed that respondent number 5 has expired, but upon inquiry they came to know that it was respondent number 6 who has expired. आपको कुछ बताना पड़ेगा.
Your Lordship, I am not in contact with the clients. We've tried, we've sent them letters also, Your Lordship. Again, a notice will be issued to them.
किसको नोटिस करते हैं हम लोग?
The
मरे हुए
parties that
आदमी
we are querying for, Your Lordship, because we have tried to get in contact with them.
इसमें हम लोग कुछ नहीं कर सकते. 2015 का 10 साल हो गया तो naturally they will lose contact. They have lost hope that this case will be decided. यही सच है ना? ओ नहीं. आपका respondent number 5 पे dead आप लिखे हैं. They have not filed any substitution. We will after some time we will say it stands abated. We just do not know. Or you have to say that he is alive.
She
Have you
said
said that
earlier-
he is alive?
On the other hand, on that day it was recorded that she is not sure. That is also recorded in
I have
that.
said that, Your Lordship, I am not in contact, but I have been informed by them only on the last, whenever the contact had
वो तो पिछली बार जब आपके पास कांटेक्ट हुआ था तो फोन पे ही कांटेक्ट हुआ होगा ना.
I have sent them letters also, Your Lordship.
लेटर आप लिखते रहिए. वकालतनामा खत्म नहीं होता है उनके नहीं आने से. So most probably करके तो कोई सबमिशन ही नहीं करना चाहिए. Next date 28 अगस्त. अवेटिंग सर्विस. 28 अगस्त. आप थोड़ा पता कर लीजिए भाई, कोई मर ही जाएगा तो क्या करेंगे? बाद में आएगा तो रिमांड हो जाएगा सुप्रीम कोर्ट से. आपको पता है?
पता लगा के ही हमें भेजेंगे.
उसमें लिखे हैं क्या एज पर योर इंफॉर्मेशन इज अलाइव? तो एक एफिडेविट फाइल कर दीजिए. कौन सी?
From supply list under heading 4 orders with defect item 6.
is still defective. Reply of what? क्या कितना परेशानी है आपको लिमिटेशन और सब?
फाइल कर दे रहे हैं नॉर्सिंग रेडी है
तो उसको कर देते हैं डिस्पोजल. क्या करना है? कितना डिले? 15 डेज. 15 डेज डिले के लिए आप इतना परेशान या 15 साल डिले पे हम लोग डिले कानून कर देते हैं. तो क्या बात है? सब्स्टिट्यूशन of some of the plaintiffs. कौन किसका डेथ हो गया है?
The defect was that plaintiff number 258 and 11G do not find mention in the memo.
Just a minute. 2, 5, 8 and 11G. G.
So far as 11G is concerned, 11G had died during the pendency of the suit and her legal heirs are on record by way of 11A to F. They are on record with us. They were there in the suit also. So far as 258 is concerned, we have filed IA for substitution list, IA number 2118/25. And there is one limitation petition in the main appeal list, 15 days delay, and a limitation in the substitution also we have filed.
तो substituted legal heirs का क्या नाम है?
Which they are, we have also filed a wakalat dawah also 27 to 25.
On their behalf?
Yes, please. They are on.
They are the appellants.
They will be now let's the appellants.
The
yes.
In the first title also they were the appellants.
They are the legal heirs of the persons who have, who have died.
They have been added as appellant.
I have filed IA for substitution.
IA number 2118 of 2025. Learned Counsel for the appellant. The Learned Counsel for the appellant has submitted that on account of office defect, this interlocutory application has been filed. She has submitted that appellant number 11G has expired during the suit.
She was there in the suit and her legal heirs were also there because the father had expired.
But she expired during the pendency of the suit, but her legal heirs are already on record. They are appellant number 11A to 11F. So far as appellant number 2, 5, 8 and 11 are concerned, they have been made party in this case. And their legal heirs and successors, the details of legal heirs and successors have been mentioned in paragraph 10 and 11 of the interlocutory application. She has submitted that
9, 10 and 11.
9, 10 and 11.
Makbul Ansari's PW plaintiff 2, 5, 8 and 11 years. 2 is paragraph 9, 5 is paragraph 10.
Okay. Appellant number, ये plaintiff
number
appellant, इसमें appellant number कौन सा होगा? Plaintiff number 2.
ये तो they have to be substituted, so they will be now added as appellant number 21, 22, 23, 24 years. That has to be done.
They will be added.
If your lordship allows the idea.
The Learned Counsel submits that the plaintiff number 2, namely Makbul Ansari, expired on 28/12/21. Plaintiff number 5, Babu Ansari, expired on 5/8/2018. And Ayub Ansari, plaintiff number 8, expired on 28/12/2021. Makbul Ansari died leaving behind his only the details of legal heirs and successors of these plaintiffs have been mentioned in paragraph 9, 10 and 11. She has submitted that she has already filed wakalatnama on their behalf. And they are to be added as co-appellants in the present case. बोलना है आपको? The Learned Counsel for the respondents has no serious objection to the prayer. Accordingly, the IA number 2118 of 2025 is hereby allowed. The Learned Council for the Appellant is directed to carry out necessary corrections, amendments in the cost item. उसको कंटिन्यूटी में डाल देंगे या कैसे? और बताइए क्या है? आइए 15 दिन का डिले है, क्या बोलना है आपको? आइए नंबर लिखिए।
IA number 2511.
आइए नंबर 2511 of 2025. The Learned Council for the Appellant has submitted that the appeal is barred by limitation by 15 days. The Learned Council has submitted that due to paucity of fund, the appellants could not take appropriate steps, and if the delay is not condoned, the appellants would suffer irreparable loss of injury. The Council for the respondents has no serious objection to the prayer for condonation of delay. Considering the submissions and being satisfied with the caution, IA number 2511 of 2025 seeking condonation of delay is hereby allowed. Okay? अब क्या है?
There's one more IA nurse, IA in the substitution nurse, we will also find the
Limitation.
yes, limitation.
This is IA number
1136.
1136. वो जो substitution allow किए हैं ना, उसी में ये IA भी allow कर देते हैं. इसका भी IA allow कर देते हैं. 1336 of 2025. This is for condonation of delay in substitution. ठीक है? इसको भी allow कर देते हैं. और बताइए what else? It is partition suit.
This is against sale and government.
Sale and
Sale and government are the respondents. So on the earlier date, 16/4/25, notices were issued to respondent number 3 and 6 was, and a service report is awaited.
I'm just asking you what is the suit about?
The suit is about land which we are claiming, and they are also criminals. And one more thing is when I was submitted about the IMS, the response, one correction was your Lordship stated regarding 11G. 11G are appellant number that has been wrongly stated. 11G, the legal heirs of 11G are appellants number 8, 9, 10, 11 and 13 already on record.
They were 11A to 11F. No?
In the report below, here they are appellants number 8, 9, 10, 11.
एक second. The legal years and successors of 11 of plaintiff number 11G, they are appellant number 8, 9,
10, 11,
10,
12,
11, 12 and 13 of the memo.
Yes.
They are already on record. And they were plaintiff number 11A to 11F in the before the learned trial court.
Yes.
Done?
Yes.
अब आपका कुछ भी बचा नहीं है ना?
नहीं, आप defect है बस. This is the only defect.
Post this case on 2nd of July under appropriate hearing. ये सारे रिकॉर्ड मिस्टर सहाय आपके ओपोनेंट आए हैं, कहाँ चले गए? He's not here. Of orders case.
Then list item
हाँ,
7,
बताइए।
second appeal 177 of
कौन
2016.
है आपके ओपोनेंट?
Mr. S. Keshav.
वो तो थे यहीं पर। आ गए। चलिए बस।
Item 7.
Seven has been called out.
What is it for?
It is an IA under the proviso to subsection 5 of section 100 to frame additional substantial question.
We'll hear it. वो एक डेट फिक्स अभी टाइम फिक्स किया डेट विल ऑटोमेटिकली we'll get date don't have cases
Item-
without dates.
Item 20.
हाँ सर आपका मैटर है ना?
Well,
Mr. Sharma, he has mentioned this case. You have got your file?
Yes.
शुरू करते हैं. Let us. चलिए बताएं.
may it please your lordship.
You are the tenant.
For my lord proceeding the matter, I have to say that there is on another item, it is item number 22. My lord has dictated on a.
I know. आज नहीं हो पाया. वो फर्स्ट अपील इतना लंबा चल रहा था. वो हिबा इज कॉम्प्लिकेटेड इशू. सोचे कि यहाँ हिबा का रोज कहानी होता है तो एक कंटेस्टेड केस में इत्मीनान से सुन लेते हैं. आ ही जाएगा.
कोई और डेट पर.
हाँ आ जाएगा नेक्स्ट वीक.
If possible in this.
यस. ये वाला बताइए. ये क्या है? दिस इज सेकंड अपील.
It's a second
What is the
appeal
substantial
against
question of
judicial-
law?
My lord,
What is the substantial question
my
of law?
lord, on 18/1/2012, the case was admitted by order number 4.
Order number 4.
My lord,
बताइए क्या substantial question of law?
let admit this appeal will be heard on the following substantial questions of law. A. Whether in view of the agreement for absolute sale, exhibit A, the suit property was a vacant land and therefore suit for eviction under the Bihar Building Lease Control and Eviction Control Act 1982 was not maintained. B. Whether the landed court bureau failed to consider and to hold that the relationship of landlord and tenant did not exist by and between the plaintiff vendor Narendra Prasad Sinha, alias Buddu Lal Sinha, and defendant appellant under the Act. Since these are the two substantial questions.
So where do you say that it is a vacant land and where is the concurrent finding on
My
this?
lord, exhibit A.
Exhibit से नहीं sir, findings से दिखा है. Because this is the foundational fact on the basis of which this substantial question of law has been framed.
My lord,
So on the basis of materials on record, there has to be a conclusive finding that it was a vacant land.
my lord.
Where is that finding? If there is a vacant land, BPC Act doesn't apply.
Doesn't.
So show us
That is
show us that there is a finding that it was a vacant land.
Point number 1, whether a suit under BBC Act is maintainable. Point number 1, page 15 of the appeal matter. Internal page.
You can para issue number 1 and 2 of the trial court judgment. Let's read this, and then we will
Trial
come to
court.
the appellate. Yes, we'll come to the appellate court later. That is at page number 31.
Issue number 1 and 2, my lord.
Yes.
Page 21. Sorry, page 31, internal page 9.
Yes.
Issue number 1 and 2. As per para 2 of the plaintiff, it is a case of the plaintiff that now here one more important thing has happened. The plaintiff has not turned up in the witness box. She has not proved the plaintiff.
Substantial question of law के beyond तो हम जाएंगे नहीं.
नहीं, ठीक है.
इसीलिए बस उसी पर. Kindly stick to the substantial question of law.
As per para 2 of the plaintiff, it is a case of the plaintiff the defendant was inducted as a tenant by Narendra Prasad Sinha in a portion of his holding with respect to Khapra Post room and a platform in front of the room in the year 1985. The defendant has admitted tenancy as per para 7 of his written statement of the year 1985. But in para 6 of his written statement, that he took vacant land and constructed corrugated roof thereon, and in para 5 of the written statement, he has stated that Narendra Prasad Sinha began to realize rent at the rate of 100 rupees per month. Defendant has argued that the vacant land was leased out to the defendant, so provision of BBC Act will not applicable and suit will not be maintainable. It was also argued by the defendant that Narendra Prasad Sinha had entered into agreement for sale. This is important, my lord. Had entered into agreement for sale of the said vacant land with defendant for consideration of rupees 15,000 and rupees 5,000 was received as earnest money. The case of the defendant is not that he had occupied another portion of the holding number 487 except the suit premises. Therefore, the premises is roofed by Khapra Post corrugated sheet is immaterial, as there is roof premises on the suit land. DW1 Raghunath Beldar has stated in para 3 of his deposition that he has worked in construction of shop. In para 2 of his deposition, he has stated that he gave wall and constructed corrugated sheets room at cost of defendant vacant land. But in para 6 of his cross-examination, he has stated as follows: नालिसी जमीन पर टूटे फूटे घर था, उसी का मरम्मत मैंने किया. This statement goes to show that the constructed house was let out to the defendant, not a vacant land. If it is assumed for the sake of argument that vacant land was let out, but in this respect it is admitted fact that construction have been made thereon and the defendant is carrying business. The existence of constructed shop has been admitted. The defendant was paying rent to Narendra Prasad Sinha is also admitted. My lord, these statement, my lord, is admitted. There is no admission to that effect.
Sorry?
There is, and the statement, oral statement of a mason.
Sir, question of law.
वही
in view of agreement for absolute sale exhibit A, the suit was a vacant. The suit property was a vacant land. How do you identify exhibit A with qua the suit property? How do you say that exhibit A was relating to the suit property? Is there, where is
yes,
the finding?
I will read that exhibit A, my lord, for my lord's kind consultation.
Exhibit A ka identity is the same as that of the suit property. From
Yes,
where
yes.
do you get this?
My lord, it is embedded in the exhibit A itself. It is embedded there. Otherwise, the
Exhibit A से बताइए कि सूट प्रॉपर्टी वही था. You see, there is an admission.
Yes.
टूटा फूटा घर था. टूटा फूटा.
मेरा एडमिशन नहीं है.
फिर किसका एडमिशन?
A mason was in cross examination. He has
Whose
stated.
witness was that?
He was.
आप ही का विटनेस था ना?
इन्हीं का विटनेस DW रघुनाथ
जिसने बनाया घर वो बोल रहा टूटा फूटा घर था उसको रिपेयर किया.
इन्हीं को बहस करने दिया जाए तो जवाबें हम खाली दे देंगे.
हम आपसे पूछ रहे हैं.
He is so much anxious. Let him argue the case.
I am just asking you. अब ऐसा
वो हम ही ना जवाब देंगे. माय लॉर्ड ही वाज वो एक मजदूर था, मिस्त्री था,
किसका विटनेस
उसको क्रॉस एग्जामिन हमने उसको लाया, चूंकि सच्ची बात वो बताया, वो तो कह दिया कि साहब हमने वहां पर बनाया है रूम, दीवार हमने दिया है। जब दीवार उसने दिया है, कॉरिगेटेड शीट उसने डाला है, तो बना हुआ क्या था पहले से? क्रॉस एग्जामिनेशन में प्रेशर डाल करके उससे कहवा लिया गया एक वर्ड।
कहाँ से बोल रहे हैं सर ये सब?
माय लॉर्ड
प्रेशर डाल के बोला?
इट इज माय सबमिशन। जब वो कह रहा है कि दीवार हमने बनाया, हम तो खुद पढ़ रहे हैं ना कि ये उसने कहा है, अपने पैरा 2 और 3 ऑफ दी एविडेंस में, विटनेस में, ये हमने दीवार बनाया, हमने कॉरिगेटेड शीट डाला। तो वेयर फ्रॉम इट केम इन द क्रॉस एग्जामिनेशन, यहाँ पर टूटा हुआ घर, इट वाज अ बिग एरिया, कहीं पर होगा कोई टूटा हुआ, अब उसको लिखवा दी कि उसी को हम बनाए। खैर एनीवे दैट विल बी मिलर्ड। Exhibit A is a written document under section 91 and 92 of the Evidence Act. We know, my lord, that the oral evidence will go in presence of a written document. Now, written document exhibited. Ji? We have it from my lord's time. Consultation of Exhibit A. I have a certified copy also.
Exhibit 1. Exhibit 8. Exhibit A.
Mine.
Pardon?
Mine Narendra Prasad Sinha. I am reading from the certified copy. Mine Narendra Prasad Sinha और Budu Lal Sinha, Wal Radhika Prasad Sinha, Maulik, मुकाम साकिन दर्जी मोहल्ला काली मंडा रोड गिरिडीह इकरार करता हूँ कि मेरे रिहायशी मकान के पूरब तरफ जो मेरा खाली जमीन सड़क के किनारे है, जिसका होल्डिंग नंबर 373 पुराना, नया 487 वार्ड नंबर 4 पुराना, नया घर पुराना, नया 12 है, दैट इज वार्ड नंबर के अंदर 15 फीट लंबा और 8 फीट चौड़ा जमीन के बिक्री का बातचीत 15,000 रुपए में ओम प्रकाश केसरी व स्वर्गीय जगदीश प्रसाद केसरी के साथ किया। He is the defendant appellant to this honorable court. उसके अंदर बतौर पेशगी के 5,000 रुपए मैंने पाया और दखल खास जमीन पर ओम प्रकाश केसरी को दिया। अब ओम प्रकाश केसरी जमीन पर अपने खर्चे से दुकान बनाकर चलाएंगे और जब तक जमीन का केवाला नहीं हो जाता है, मुझे 100 रुपए प्रति माह जमीन के उपभोग के लिए दिया करेंगे। हसबहाल सदर या बिक्री का इकरारनामा ओम प्रकाश केसरी को लिख दिया, जो वक्त पर काम हो गया। Now he has signed as Narendra Prasad Sinha or Budulal Sinha, and one Mohan Prasad Gahlot has also signed, and the purchaser of Prakash Kesari has also signed. I am reading from the certified copy of the Exhibit A.
ये आपका एग्रीमेंट 86 का है ना?
जी
86 का एग्रीमेंट
86 का
आपके रिटन स्टेटमेंट में है that the defendant had put a structure over his portion of leased out to him at his own cost and covered the roof with corrugated sheet in the year 1985. तो ये जब एग्रीमेंट हुआ था तो there was already a structure with corrugated sheet in the year 1985.
My lord,
This is your written statement.
my lord. After that, paragraph.
Para 7 पढ़िए सर.
Para 7 में जी. Para 8 में kindly.
8 भी पढ़ेंगे, 5 भी साथ में.
हाँ, जी. The defendant put a structure over his portion leased out to him at his own cost and covered the roof with corrugated sheet in the year 1985, which is still in existence. Hence, it is far from truth that the suit uses this khapra post. That is irrelevant. Khapra post हो या corrugated sheet हो. Under the act, it will mean the same. Whereas sir 8 kindly देखा जाए, that Narendra Prasad Sinha, that is alias Budulal Sinha, had as such entered into a concluded contract for sale of the suit premises. That is exhibit A minor.
नहीं आप हमको ये बताइए, आपका स्पेसिफिक स्टेटमेंट है कि 1985 में यू कंस्ट्रक्टेड और व्हाटएवर रूफ कवर करके कॉरिगेटेड
रूफ प्रीमिसेस जो भी
ठीक है. उसके बाद आपका 1986 में आप एग्रीमेंट है जिसके बेसिस पे आप बोल रहे हैं कि खाली जमीन. 85 में ही स्ट्रक्चर वाज ऑलरेडी देयर.
It was a bigger land. It will come from the evidence of rather from the exhibit of the plaintiff.
देखिए जो आपको इविक्शन सूट है वो सिर्फ स्ट्रक्चर का है. जमीन का इविक्शन सूट तो फाइल ही नहीं हुआ है.
My lord, in fact, what has happened?
क्योंकि इविक्शन सूट में कुछ एरिया बाउंड्री दिया हुआ है लेकिन कोई एरिया नहीं दिया हुआ है, खाली स्ट्रक्चर का इविक्शन सूट है.
My lord,
जमीन है आपका, आप एंजॉय करिए. कहाँ कौन मना किया?
In fact, उतना ही जमीन ही है 15 फीट into.
नहीं ऐसा नहीं है.
Schedule of the property देखा जाए.
शेड्यूल ऑफ द प्रॉपर्टी
15
देख
feet
लीजिए.
into 8 feet.
नहीं है ना, ये नहीं है शेड्यूल ऑफ द प्रॉपर्टी में. आप देखिए शेड्यूल ऑफ द प्रॉपर्टी आप देख लीजिए प्लेंट का. Look at that schedule of property.
Well, holding number is same.
होल्डिंग नंबर है भाई. होल्डिंग नंबर के साथ होल्डिंग नंबर होने से क्या हुआ? होल्डिंग नंबर के साथ मान लीजिए किसी होल्डिंग में कोना में कोई रूम बना हुआ है. The eviction is only in connection with that room.
My lord, we kindly consider exhibit A जो हमने दिया.
Exhibit A is not matching exactly with the schedule of the property. It is not matching.
My lord, then the plaintiff will have difficulty because उतना ही जमीन ही है.
उनकी डिफिकल्टी की आप चिंता मत करिए, आप अपनी चिंता करिए कि आपका एग्जिबिट ए आप बताइए कि शेड्यूल से मैचिंग.
हाँ, हम प्लेस कर देते हैं.
प्लेस करिए.
My lord, I will read me lord holding number 373 Purana, and that is the
एरिया नहीं लिखा है सर.
my lord, वो होल्डिंग उतना ही है.
वो कैसे पता?
उसमें 1 इंच भी ज्यादा जमीन नहीं. होल्डिंग नंबर 373 ओल्ड 487 प्रेजेंट, ये शेड्यूल में लिखा है. और जो एग्रीमेंट फॉर सेल है इकरारनामा एग्जिबिट ए, उसमें लिखते हैं कि होल्डिंग नंबर 377 पुराना
के अंदर दिस एग्रीमेंट इज अ पार्ट ऑफ दैट होल्डिंग. एग्रीमेंट इज अ पार्ट ऑफ दैट होल्डिंग. उसमें कोई वेकेंट एरिया का कुछ एग्रीमेंट है, लेकिन दिस होल्डिंग नंबर जो शेड्यूल ऑफ प्रॉपर्टी है दैट इज कंस्ट्रक्टेड एरिया, एंड एज पर योर रिटन स्टेटमेंट आल्सो 85 में देयर इज ऑलरेडी अ कंस्ट्रक्शन.
my lord will kindly consider that this is the land which is existing and there is not a single inch of land extra other than this land.
ये हमको आप हमको कहीं से दिखा दीजिए कि इसके अलावा कोई एरिया है ही नहीं. शो मी फ्रॉम समवेयर जो आप सबमिशन कर रहे हैं खाली सपोर्ट करिए फ्रॉम रिकॉर्ड्स दैट ये होल्डिंग है, इसका टोटल एरिया इतना है और इसके अलावा कुछ नहीं. केस ही यही है कि उस होल्डिंग के एक पोर्शन में ये खपड़ा पोस्ट रूम में आपको टेनेंसी मिली 1985 और आपने अपने रिटन स्टेटमेंट में एडमिट किया है कि कंस्ट्रक्शन 1985 में हो चुका था.
हम ही करवाए,
वो भी करवाया था, इससे क्या फर्क पड़ता है. और ये जो एग्रीमेंट है आपका ये 1986 का है,
86 का
जो उसी होल्डिंग का एक पोर्शन है जिसका कुछ वेकेंट लैंड है.
My lord will then kindly consider that rented premises, even if it was on rent from 1985, is ceased to exist on execution of this Exhibit A in 1986. टेनेंसी का एंड हो गया वहाँ, और वहाँ से लैंडलॉर्ड टेनेंट के जगह पर वेंडर और परचेजर का स्टेटस एक्रू किया. And there I have a judgment also.
जजमेंट दिखाइए.
Madam?
कि अगर मान लीजिए कि इसकी एग्रीमेंट हो जाता है तो द प्रॉपर्टी विल सीज टू एग्जिस्ट.
Property नहीं,
the structure will cease to exist.
But my lord, the relationship will cease of landlord and tenant.
Agreement होने से.
हाँ?
कौन सा जजमेंट? इसका स्पेसिफिक परफॉर्मेंस करवाएंगे इस एग्रीमेंट का.
My lord, the gentleman was ailing and the plaintiff, my lord, who was also having a shop room there, he purchased the property in his wife's name and even in the witness box, the plaintiff has not come to depose. So the pleading is without any proof.
Admission पर है sir. Case can be decided on admission. It is an admitted fact.
But
Plain written statement से ही तो पूरा कहानी पता चल
the
जाए.
plaintiff has not come to say this is my plaint.
आपका written statement में अगर admit हो जाएगा कोई भी fact, तो क्या ही आके क्या बोलेगा plaintiff?
My lord will kindly consider, हमने क्या कहा है कि 85 में हमने बनाया, हमने ये भी तो कहा है कि 86 में हमने खरीदने का इकरारनामा किया. And this judgment of paragraph 8 I will place, R. Kanthimati versus Beatrix Riviere. The decision, may I read paragraph 8 of this judgment? The decision clearly spells out that once there is an agreement for sale between a landlord and a tenant, the old relationship as such comes to an end. The court further proceeds, but my purpose will be served only on the first two para sentences. It goes on record that even after cancellation of such agreement of sale, the status of tenant is not restored as such. In other words, on the date of execution of the aforesaid agreement of sale, their status as that of landlord and tenant changes into a new status as that of purchaser and seller.
कल मिस्टर शर्मा आप ही का एक केस है ना? इस ज़्यादा टाइम नहीं लगेगा. इनको अर्जेंसी essay number 80 of 2011. Upon mentioning of the appellant, this matter has been taken out of turn. Counsel for the parties are present. The hearing has commenced. Since the court time is over, post this case for further arguments tomorrow at 10:30. कल पहला केस 10:30 बजे. ठीक है, हम सुने हैं सर आपका. आपको जो भी कुछ समझ आए थोड़ा मोड़ा नोट अगर बनाएंगे तो अच्छी बात है, नहीं तो
I will try. एक हमारा सबमिशन है. Tomorrow is a date in.
कल सर 12 बजे तक आपको जजमेंट मिल जाएगा, आप चिंता नहीं.
हाँ नहीं, एक स्टे पिटीशन हम इसलिए दे दिए.
कोई जरूरत ही नहीं है सर, कल फाइनल.
Number 7 was also supplementary. If the order was not complied with, the secretary was required to appear through online. Order has been complied with.
So should I record? Have you filed your application?
So far as JPS, part of JPSC is concerned, it has been complied.
Serial number 7.
Yes.
Serial number 7 में लिखिएगा. The learned counsel for JPSC, Mr. S. Piparwal, has submitted that pursuant to last order, the order passed by this court has been complied so far as JPSC is concerned, and therefore there is no need for personal appearance of
Through online.
personal appearance of secretary to JPSC. He was directed to appear online if the order is not complied. Right? Counsel for the petitioner submits that it does not dispute that so far as JPSC is concerned, the order has been complied. However, he submits that the order passed by this court is still required to be complied by
The university and the HRD department.
by university and the state government.
State.
कहाँ है, कौन है यूनिवर्सिटी और स्टेट गवर्नमेंट? Pose this case on 11th of July. In the meantime, the state and the university shall file their. उनको खबर कर देंगे.